Advocate Hood.
My name is Lawrence Hodes. I act for accused number 1. The representative of accused number 2 isn't Advocate Lawrence, it's Shane Matthews.
Matthews.
Very good.
My apologies. Yeah.
Advocate Matthews.
I'm ready to proceed.
Thank you. Thank you, Advocate Hodes. You may proceed.
Accused number 1, and who is referred in the application to as the first applicant. Worship, rather than duplicating matters, accused number 2 is referred to in the application as the second applicant, and he has signed a confirmatory affidavit, so to don't repeat everything and have a duplication. Worship, in this regard, we have a written application that's been signed and deposed to by the first applicant, and the confirmatory has been signed and deposed to by the second applicant and duly signed by a Commissioner of Oaths. I beg leave to hand a signed original to your worship, and a signed original from my learned friend as well.
Thank you.
Easier to follow.
It will indeed.
Worship,
Thank you.
with your worship's leave, the intention would be to launch the application, go through the factual verments from our side, thereafter by the second applicant, the state, and thereafter, once we've dealt with the factual verments and the base of the application, address your worship on the law. So it's first the facts and then the law, if we may, your worship. Thank you, worship. Worship, it's headed in the Regional Division of the Eastern Cape, held at East London, case number 446/2020. In the matter between Julius Malema, first applicant, Adriaan Snyman, second applicant, and Regional Magistrate Mrs. T. Udifir, respondent. Notice of motion. Take notice that application will be made on behalf of the above mentioned applicants. This Honourable Court on 2 February 2023 at 0900 hours. Also soon thereafter as the matter may be heard for an order in the following terms. 1. Magistrate Mrs. T. Udifir recuses herself from presiding as the magistrate in this matter. 2. Proceedings must commence de novo before another magistrate. 3. Further instruct alternative relief. We then also allude to the fact that the affidavit of the first applicant, Mr. Malema, and the second applicant, Mr. Snyman, will be or annexed in support of the application. It's duly signed by both firms of attorneys, Your Worship, the combined application on the 2nd of February 2023. The two attorneys being Ian Levitt's attorneys and Carlitz Crockett and Associates Inc. for the second applicant. Worship, I apologize, Your Worship, will see there's a spelling mistake in the name of the first applicant. I accept responsibility. I'm not very good at typing and we didn't have normal facilities available. It's then headed in the Regional Division of the Eastern Cape, held at East London, case number RC 446/2020, the same heading. And then we have the first applicant's founding affidavit, which reads as follows. I, the undersigned Julius Malema, do hereby make oath and state. The parties. 1. I am an adult male Commander-in-Chief of the Economic Freedom Fighters, the EFF. I am accused 1 in the criminal matter and the first applicant in this application. The facts contained herein are true and correct to the best of my knowledge and belief, and save where the context states the contrary, or within my personal knowledge. Where I make submissions on law, I do so on the advice of my legal counsel. 2. The second applicant is Adriaan Snyman, an adult male businessman who is my co-accused and accused 2 in the criminal matter, as well as the second applicant in this application. 3. The respondent is the regional magistrate, Mrs. T. Udifir, who is currently the presiding officer in the criminal trial against the second applicant and me in the regional division of the Eastern Cape held at East London. Background. 4. This application is premised upon the constitutionality recognized right to a fair trial as embodied in Section 34 and 35 of the Constitution of the Republic of South Africa, Act 108 of 1996, hereinafter referred to as the Constitution. In particular, the second applicant and I specifically rely upon our right to justice and access to court as envisaged in Section 34 of the Constitution, which provides as follows. Access to courts. Everyone has the right to have any dispute that can be resolved by the application of law, decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. 5. The charges against me relate to an incident that is alleged to have occurred in this Honourable Court's jurisdiction on 28 July 2018 when we were celebrating the EFF's 5th birthday. 6. The second applicant and I were summoned to appear before this Honourable Court on 27 November 2019. We did so and were subsequently released on warning. 7. Thereafter, there were several postponements until the matter eventually proceeded to trial before the respondent. I pleaded not guilty to the charges on 1 March 2022 and put the state to the proof of the allegations against me. My right to do so is also recognized in Section 35 of the Constitution. 8. The second applicant also pleaded not guilty on that day, but submitted a detailed explanation of his plea in terms of Section 115 of the Criminal Procedure Act, 51 of 1977. 9. The state thereafter commenced by leading the evidence of 9 witnesses, the last of which was Colonel Makwadleka. Once he had completed his evidence-in-chief, cross-examination, re-examination, the respondent reserved unto herself the right to question this witness so as to avoid having to call him in terms of Section 186 of the Criminal Procedure Act when the trial continued. 10. The matter then recommenced on 30 January 2023. That day, the respondent then asked if my co-accused counsel had completed his cross-examination of Colonel Makwadleka. He confirmed that he had. The respondent then asked the prosecutor whether he had any re-examination. He then stated that he also completed his re-examination. The second applicant's counsel then advised the respondent that all questioning had been completed, but for the respondent's possible questions to clarify issues. The respondent then had regard to a note and stated that she did not have any questions for this witness and consequently excused him. 11. Thereafter, the prosecutor sought to introduce and play video evidence in court. This was opposed by the second applicants and my counsel, which in turn resulted in legal argument being presented concerning the admissibility of video evidence. 12. The respondent subsequently ruled that the video evidence was real evidence and could be played before her without the need for a trial within a trial. The prosecutor then commenced to present the evidence of what he referred to as the gear house witnesses with the view to playing the video evidence in court. 30. The first gear house witness was Mr. Sibusiso Professor Nkobo. He presented evidence concerning 2 portions of video footage that had been in the possession of gear house, but which he had not personally captured. He was then asked to look at a third footage, the source of which was unknown. Once his evidence-in-chief had been completed, cross-examination took place and he was then re-examined. 40. Thereafter, the respondent requested the third video footage to be shown to this witness, despite the fact that the witness had testified that this footage did not emanate from gear house. She then asked him whether he had seen anybody that was familiar to him. He replied that he had and identified me. She then asked him whether there was anybody else, save for me, that he could identify on his footage. He then replied that there were other people that he did not know. She then again asked him whether anybody else had caught his attention. He replied in the negative. She then repeated the question asked, not at all. The witness confirmed that he could not identify anyone else. 50. Thereafter, the respondent asked all of the legal representatives whether they had any further questions. The prosecutor and my counsel had no questions, but the second applicant's counsel put to the witness that the third video was not his company's video, and he could not even say whether it was from the day in question He agreed with this contention. The respondent then commented that that had been established. 16. This question by the respondent cannot, in my respectful submission, be considered to have been required to clarify any particular point. The focus of her questioning undoubtedly was to get the witness to identify the second applicant and me on the third video footage, the source of which was clearly unknown. 17. My submissions in this regard are fortified by that witness's previous responses to questions by the prosecutor when he asked the witness whether he knew the second applicant, and he had replied in the negative. He had also asked whether he had seen him on 28 July 2018, to which he answered in the affirmative. However, when asked where he had seen him, he had answered that he could not be precise as he was busy working. There can thus be no doubt that at the very least the perception created by the respondent's questions in this regard was that she was attempting to assist the prosecutor and not clarify anything. 18. The second Gearhouse witness was Mr. Ashley Singh, a branch manager. He had not even been present at the event on 28 July 2018. He had merely been requested by the investigating officer, Brigadier Governor, to hand over the video footage, including that which was contained in the first and second videos that had been played in open court. Once his examination in chief, cross-examination and re-examination had been completed, the respondent once again posed questions to him under the guise of obtaining clarification. 19. Her questions related to the theft of the laptop, which was no longer available, and she in particular queried its ownership and upon what basis he could say that the identified the same. She then asked him if he still had the hard drive in his possession. 20. And the respondent then of her own accord asked him whether coming to court had affected his company. He answered that there were no tangible repercussions, but that he would rather not be here at court. He went on to say that the defendants were good clients, so it was awkward. The respondent then asked him, are they still clients, to which he responded in the affirmative. She then asked him whether he had a good relationship with me. He then confirmed that he did. 21. The respondent then asked him how it was possible that he could not identify the people images. The respondent then remarked that he seemed uncomfortable. She then confirmed what had been his motivation for seeking legal advice before prolonged to the client. 23. This line of questioning further caused the second applicant and me to apprehend that the respondent was biased in attempting to assist the state by eliciting evidence to the effect that the witness was trying to assist the second applicant and me rather than the state. 24. On 1 February 2023, the second applicant and I had the clearest indication of bias on the part of the respondent when the testimony of Mr. Samuel Ntandazo Kwate had completed. During his evidence in chief, he had expressly stated that he had not seen who was shooting and that he had merely heard the gunshots when watching a video on his phone after the event. During his testimony, he clarified that the video that he had seen did not show. Cross-examination and re-examination, he was questioned by the respondent once again under the guise of seeking clarity to cross-examine this witness. 27. In her questions relating to clarification, the respondent confirmed that he had been responsible for the graphic display but had not watched the event. She then put to him that she presumed that he knew who was present on the stage at all times. He replied that he did not know who had been on the stage at all times. She then asked him whether the people changed. He replied that they did. There were a lot of activities, so people came in and went out. 28. The respondent then requested that the first and second videos be played for the witness without sound and that the operator must pause the video when she told her to do so. The first video was played, and after having the video paused and having the witness state out loud that each person was wearing at least one clothing item, she told the witness to look at the far left corner and see what the person was wearing. The witness said that that person was dressed in red. She then told the witness that that person was also wearing jeans. He agreed. She then told him to look carefully and see that the person had a red long-sleeve buttoned shirt with a collar. The respondent then pointed out that the other people on stage were wearing red jackets and tops, but not red long-sleeve buttoned collar shirts. 29. The respondent then asked him whether that person had anything in his hand. The witness moved closer to the screen and the operator utilized the cursor to point at that person's hand, which elicited a response from the witness that he could see something. The respondent then asked the witness whether he could describe what was in the person's hand. He responded in the negative. 30. This questioning resulted in the second applicant's counsel objecting to this line of questioning. My counsel also objected and placed on record on my instructions the various incidents which had occurred, and that I may apply for the recusal of the respondent. Reasonable apprehension of bias. 31. I became upset and stated that the respondent was prosecuting and not doing a job as a magistrate to clarify issues. There is no doubt in my mind that this line of questioning was intended to assist the prosecution in proving the allegations against the second applicant and me. I thus have a reasonable foundation for my apprehension of bias on the part of the respondent. 32. The respondent attempted to explain that she did not overstep her authority. Our counsel then requested a short adjournment. The prosecutor approached my counsel and requested that regardless of what action we decide to take, we complete the evidence of the current witness. My counsel then placed this on record. 33. The respondent, who at that stage recorded that she had already completed her questions, then asked further questions of the witness relating to the previous witness, Sibusiso, and what his position at Gearhouse was. She then also asked the witness what his position and responsibility in Gearhouse at witness that prior to the respondent's questioning, he had not noticed the red long-sleeve buttoned collar shirt, whether that person had anything in his hand, and had not known which people had been on stage. He conceded that this had been the case. 35. During the course of the exchange between the respondent and the witness, the respondent put certain things to him to which he had responded, "If you say so." 36. It was very clear to all present that the respondent was attempting to get the witness to identify either the second applicant or me on the relevant video clip. It was further evident that she had taken a stance that was not in my co-accused and my favor, but clearly aligned to that of the state. 37. After a few further questions by the respondent to the witness regarding the witness was adjourned for the argument of this application for the respondent's recusal. 38. The cumulative effect of the respondent's questioning of the last three witnesses under the pretext of seeking clarity is that these questions clearly favored the state and prejudiced the second applicant and me. There can be no doubt that these questions were aimed at bolstering the state's case against us. We thus have a reasonable apprehension of bias and do not believe that we will receive a fair trial before the respondent. 39. When these events took place in court, members of the gallery also expressed similar views and required. I've been advised to and respectfully submit that the established principle in our higher courts is the effect that the second applicant and I are required to establish a factual basis for a reasonable apprehension of bias. 41. Due regard being had to the respondent's conduct as detailed above, I have no doubt that all of the questions posed by the respondent were not aimed at seeking clarity, but rather to assist the state and to fix or bolster its case against us. 42. Further legal argument will be addressed to this Honourable Court in this regard on our behalf, but I've been advised to and respectfully submit that the most recent decision by the Honourable Justice Kun in the matter of the State versus Jacob Gedlikisa, Zuma and TEL South Africa Proprietary Limited deals in great detail the legal principles to be applied and ought to be followed in this regard. 43. I specifically refer in this regard to the legal principles applicable to such an application that are set out in paragraphs 22 to 49 of that judgment, which end with the following, quote, "The question is whether the alleged manifestations of bias, viewed either singly or collectively, would give rise to a reasonable apprehension of bias on the part of a reasonable, objective and informed person. Factors raised, if considered individually, attacking cumulatively, that might be justified." 44. Finally, Kun J referred to the leading South African commentaries on criminal procedure in paragraph 83 and held that, quote, "The integrity of the judicial process must be protected against any reasonable taint of suspicion so that the public and litigants may have the highest confidence in the integrity and fairness of the courts." 45. I therefore, on behalf of the second applicant and myself, having been duly authorized to do so, pray for the relief sought in the notice of motion annexed here 2. It's then signed by the deponent, the first accused and first applicant, on the 2nd of February 2023 at East London, he having duly taken the oath. There's also, as I alluded to earlier, Your Worship, a confirmatory affidavit by accused number 2. I beg leave to read that onto record. It has the same heading, Your Worship. Second applicant's confirmatory affidavit. I, the undersigned, Gerhardus Adriaan Snyman, do hereby make oath and state: 1. I'm an adult male businessman currently employed as General Manager at Tactical Security Services CC. 2. I am the accused 2 in the criminal matter and the second applicant in the application for the respondent to recuse herself from presiding over the criminal matter. 3. The facts contained herein are true and correct and fall within my personal knowledge. 4. I have read the affidavit of the first applicant and confirm the contents thereof insofar as they pertain to and or refer to me. 5. I specifically refer to the undeniable fact that it is obvious that the respondent's questions are not aimed at clarification, but rather at attempting to have the relevant witness identify me. 6. Additionally, the fact that the video in question was not created by Gearhouse means the respondent was using this witness to attempt to identify me as being the person in the video. The fact that he had no knowledge of that video and did not know where or when it had been created or by whom means that her questions were inappropriate and solely intended to bolster the state's case against me in particular. 7. I accordingly ask that the relief prayed for, the notice of motion to which this my confirmatory affidavit is fixed, be granted as prayed. It's then signed by that deponent as well, also on the 2nd of February 2023, having duly taken an oath which was signed by the Commissioner of Oaths. That's the factual basis, Your Worship, that's before Your Worship. As I alluded to earlier, I would like to address Your Worship at the later stage on the law. We also, Your Worship, have a copy of that judgment by the Honourable Mr. Justice Kun and a few other articles and judgments that we'll beg to leave, which we beg leave to hand up in due course, Your Worship. Thank you, Your Worship.
Thank you. Advocate Matthews.
Thank you, Your Worship. I confirm that the affidavit of the second applicant has been read into the record by my learned colleague. And I refer specifically to paragraph 14 of the first applicant's affidavit as reiterated in paragraph 6 of the second applicant's affidavit. While we are dealing with the grounds of this application, I may state the following, Your Worship. We are all aware that the proceedings in this court are being recorded, and it therefore is not difficult for us to obtain a true version of exactly what was said and what was not said. I have thought carefully about this and have tried to find mind to establish as to whether this might be some or other clarification of the issue. We should not lose the fact that in his evidence in chief, Noble distanced himself from that video, clearly stating it was not a gear video, that they did not have cameras on the back of the stage, and that he himself could not even identify where or when this video was taken. It is obvious to me and my client, Your Worship, that the sole purpose of your questioning of that particular witness under the circumstances that it took place was nothing other than an attempt by you to get Mr. Ingogo to not only identify Mr. Malema on the video, but also to identify the second applicant, Mr. Snyman. The reason I'm saying this is because we may as well have asked somebody from the street to come inside, look at the video and say, now, can you identify anybody on this video. And when we look at the precise words that you used, is there anybody in this video that stands out for you? What conceivable that knows nothing about this video? And the only conclusion I can come to is that you wanted Mr. Ngobo to identify the accused, number 2, as being part of that video. Now, that's not clarification, because you're not clarifying something Mr. Ngobo said. That is a direct attempt to assist the state in its proof of the case against the accused, number 1 and 2, and the first and second applicants in this matter. We have looked at this over and over and over to ensure that as an officer of the court, I should not stand in this court and accuse you of doing that. However, I can only, with respect between my client and myself and anybody else, attorneys that have watched that particular clip, the only conclusion we can draw is that you entered into the arena, you should not have done so, that whether your purpose is bona fide or not, and as we will see in the legal argument to follow, actual prejudice is not necessary in a recusal application. Where is the reasonable perception of bias from the accused, then a presiding magistrate must recuse herself. It doesn't have to be actual bias. It doesn't have to be, Your Worship, I don't have to stand here and say you are actually biased. What I'm saying to you with respect is that because you did that, it has created the impression with the reasonable accused that I'm not going to receive a fair trial. You could see by the reaction of accused number 1 that he immediately thought that that was so. What happened after Mr. Ngobo's evidence, because it was at the end of the day and we adjourned till the next day, is not something that Your Worship would even be aware of. But immediately there was a problem. I was accused that I was not looking after the interests of my client because I should follow why I could question. It has created a reasonable apprehension that you're not going to be impartial in this particular matter. Played a very important role in enforcing legislation and other aspects in our darkest days. There is a suspicion among many people of the judicial system. It is very, very important. And we see ourselves as the last bastion of hope in this country, that we can impartially and without prejudice to any person because of who he is, what color he is, we will apply the law perfectly. And unfortunately, my lady, when this happens, something of this nature, the perception is created, many perceptions are created. And without saying directly that you are biased, I submit that these facts prejudice to the state. If they wish to again proceed with the matter, they can do so. Thank you.
Thank you. Advocate Caesar, do you want to address on the factual issues raised now, or once the legal arguments have taken place by Advocate Odes and Matthews?
I will do once everything has been completed. I will.
Bishop, a reasonable apprehension of bias on the part of, whilst an application for leave to appeal might be set on the competence of the presiding officer. This is not the case here, Your Worship, and I make that very clear. The case law dates back few days ago, as I already alluded to, the decision by Justice Kun, and there is also a very recent decision in this division, and they conclude differently, but they are distinguishable, and I'll make it very clear. So my starting point, Your Worship, would be the principle that was enunciated by the Rent Board. It's reported at 1943 TPD 246 at page 252, where it states as follows: judges and injustice. With this trial will result accused. It's a decision of Lin and Moch, the decision of a dispute to which acting judge found had disbelieved her, and she said that was on account of the fact that there was this animosity. There was no outward manifestation of it, but in a full bench decision given by the Honourable Justice Heffer in the Supreme Court of Appeal, he alluded to what is now referred to as the reasonable apprehension of bias on the part of a presiding officer. So, whereas the application had been dismissed by the first judge as being frivolous and being disbelieved and possibly scandalous, reasonable apprehension of bias was sufficient to justify a recusal. There are numerous cases that then follow along that line. There's a case of President of the Republic of South Africa versus SAFU, which is the leading authority. That in turn is the decision of the Constitutional Court, which is referred to in all of the leading authorities on this point, and they make it perceived or to prove actual bias. It is the mere reasonable apprehension of bias that suffices in the circumstances. And these decisions have been followed the principle. There's the case, Your Worship, of Sawana and another versus magistrate that were placed before the magistrate, so the magistrate felt entitled to proceed with the trial against the accused, and on appeal in the Cape Provincial Division it was set aside because of the next case, Your Worship, is one of Matopo and others versus Magistrate Bila, spelled B-H-I-L-A, and another. It's a Zimbabwean decision, Your Worship, 2010, JOL 26251-ERA. What had happened there, Your Worship, is used what was the basis of the defense, and it was held that the presiding magistrate ought to have recused himself, obviously didn't, which resulted in the appeal. The last decision by the Honourable Mr. Justice Hendricks as the DJP, where the one party had come before the magistrate and she suggested that the person utilise a particular attorney. She then did so. The matter then proceeded. This was brought to the attention once again as a refusal to recuse, which resulted in an appeal that succeeded. But Your Worship, that's all illustrative of the principles, and I'd like to hone in, Your Worship, on more recent authority. Firstly, Your Worship, there is a very, very informative paper by Justices Cato Regan and Edwin Cameron, former Justices of the Constitutional Court. I have a copy for my learned friend and for Your Worship, which I believe to hand up.
Thank you.
With the principles that we refer to. So in the introduction, Your Worship, the learned justices write as follows. The South African Constitution confers extensive powers on the South African judiciary to uphold the rule of law. In so doing, it stipulates that courts must be independent and subject only to the Constitution and to the law, which judges must apply impartially and without fear, favour or prejudice. That's section 165 sub 2 of the Constitution, Your Worship. Judicial impartiality is thus a principle at the forefront of the Constitution. The Constitution is merely a recognition of the common law in this regard. As in many Commonwealth countries, it is generally or has a clear conflict of interest. So one, it mind of the accused. In presence of the reasonable, objective and informed person would, on the correct facts, apprehend that the judge has not and will not bring an impartial mind to bear on the adjudication of the case. That is, a mind open to persuasion by the evidence, the submission of counsel. The reasonableness of the apprehension must be assessed in the light of the oath of office taken and experience. it must be assumed that they can disabuse their minds of any irrelevant personal beliefs or predispositions. They must take into account the fact that they have a duty to sit in any case in which they are not obliged to recuse themselves. At the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite to a fair trial, and the judicial officer should not hesitate to recuse herself or himself if there are reasonable grounds on the part of the litigant for apprehending the Worship. At page 7, under the heading, the chimera of absolute neutrality, be influenced by the society in which, at the foot there's a heading, Your Worship, the top of page 10 as follows. The question whether there is a reasonable apprehension of bias must be determined on the facts before the court. Information can therefore not succeed. And I will show you, Worship, that's one of the distinguishing features between the two recent cases that I will allude to in due course. Your Worship, at at page 12, under the heading Conduct of Proceedings, Constitution, Rights of those arrested, detained and accused. Judge is there to ensure that justice is done. Thus, as the Supreme Court of Appeal recently remarked, fairness of court proceedings requires of the to point out when evidence is irrelevant and to refuse to listen to irrelevant evidence. A supine approach towards litigation by judicial officers is not justifiable either in terms of the fair trial requirement or in the context of resources. On the other hand, the learned authors continue, a judicial officer must strive to ensure that those involved in the trial perceive the conduct of the trial to be fair. These potentially countervailing requirements mean that a judicial officer must walk the thin dividing line between managing a trial and getting involved in the fray. And there's a reference, as your Worship will see, to the Mark case that I've referred to at the foot of that page. But I then turn to page 14, Your Worship, where the learned authors state as follows. Where, it's in the second paragraph, Your Worship, where the judicial officer gets so involved in the fray that it results in a reasonable apprehension of bias, the ordinary but not inflexible procedure is for a dissatisfied litigant to pursue the complaint by way of appeal or review once the proceedings are complete. As Shana J.A. observed in R versus Silver, the grounds related purely to in the course of a trial on the ground that the judicial officer has shown bias by his conduct of the proceedings. And this is not surprising, since the ordinary way of meeting any apparent bias shown by the court in its conduct of the proceedings. And finally, Your Worship, at the conclusion on page 17, the principle that judges must act impartially and without fear, favour or prejudice is foundational to South Africa's constitution, both South African common law jurisprudence upon which to build, as well as the jurisprudence of many other jurisdictions, particularly in the Commonwealth, as this chapter is illustrated. Cultivating a habit of impartiality and open-mindedness is a continuing task for judicial officers in every democratic state. Nowhere is that task more important or difficult than in recusal applications. It will indubitably be made easier by studying how judicial colleagues in other jurisdictions address the questions they raise. So, Your Worship, even they recognize how difficult the task is that we have at the moment, and that they go through the principles which are enlightened. The next decision, Your Worship, is the decision in the official, a decision of Mrs. Justice Stretch. I beg leave to hand a copy of that judgment.
Nkolo versus the state?
Yes, Your Worship.
I do have a copy.
Yes, Your Worship.
But I would, maybe I might have, thank you.
Your Worship, there, Your Worship, the issue was that the trial was being unreasonably delayed by the defense in what's been colloquially termed in South African parlance as the Stalingrad defense, and the judge had refused basic averments, and these are captured, Your Worship, at page 3 of the judgments as being the following. The first was that the presiding Judge Stretch had indicated in the presence of the applicant's newly appointed counsel and the prosecutor that she was not prepared to entertain any further applications for the trial to be adjourned. Secondly, that she had informed the applicant's attorney that she was not Kunjay, and that the applicant was not the former President Jacob Zuma, which is very ironic with what's now transpired, what I'm going to be referring to. And thirdly, that during the course of exchanges with accused two's attorney, who was also moting for a delay in the commencement of the leading of evidence, pending representations which accused two was making to the Director of Public Prosecutions, she had said that we all know and the accused are taking opportunity after tactic. I thought that to traverse this, whether that is still going to be pursued, but the point is to refuse. Backwards to accommodate to be admissible, she made as detailed in all of and he had been very 20 issue includes in 35 that the application was not shared. We say that might require that recusal include inter alia B. Unconstitutional demands the fundamental principle of not explicit emphasis that goes to the source. At the same time, that Mr. should not hesitate. The reason was not refers to Sakawa versus Irvin and Johnson. Office is action on the part of a judge. The court will not inquire where of South Africa. Within paragraph 8, there's a quote from the apprehend that the judge has not or will not questions of counsel. And their ability to pursue paragraph 45 of Wansley and District Licensed Victualers Association Devlin, not actually biased, and did not determined upon the probability. The question is whether there was an indication that the litigant would not be perceived to have a fair hearing. But taken cumulative, matter might be justified. And having had regard to all of those cases and the facts of the matter as follows. Reasonable and inevitable apprehension that if they are presented again, they will be decided by me in a similar manner. So there he had asked questions and received answers and made findings in his judgments that cumulatively considered would result in this apprehension. And then ultimately in paragraph 79, and hence on issues which have now arisen or are reasonably certain to arise will be apprehended to be. And then finally, Your Worship, I'm sure you're pleased to hear this at paragraph 83, above conclusion, His Lordship states as follows. The aforesaid conclusions require that I recuse myself from the trial. It is what the sound administration of justice, the requirements of the Constitution, and my conscience dictate. No reasonable negative inferences as to whether the trial is constitutionally fair should be allowed to arise. Mr. Zuma argued that it is not enough for a judge to be just in his judgment. He should strive to make the parties in the community feel that he is just. He owes this to himself, to the law, and to the position he holds. That submission is correct. The integrity of the judicial process must be protected against any reasonable taint of suspicion, so that the public and litigants may have the highest confidence in the integrity and fairness of the courts. So now, applying these principles, Your Worship, to the facts as alluded to, and I believe even undisputed in the affidavit of the applicant, one must not only have regard to the fact that you don't have to actually show bias, it's a reasonable apprehension of bias, and it's not that it's borne out by one simple comment or one simple gesture, but it's the cumulative effect of the instances that are highlighted there and detailed there of the questioning by Your Worship of the state witnesses and what's perceived by the accused on oath to have been the case. Both of these accused state unequivocally, Your Worship, that they have a reasonable apprehension of bias on account of the cumulative effect of the questions asked by Your Worship. Now, I don't attribute any direct bias to Your Worship, and it's not a personal attack. I need that to be understood. I would be failing in my observation of integrity to myself if I made such a comment, but if one has regard to the conduct, Your Worship, and Your Worship said to the last witness, look at the screen. Do you see what this person is wearing? And I'm paraphrasing, Your Worship, but it was in the light of the phone. It was red and jeans. Do you see that he's wearing a buttoned shirt with a collar? Yes. Do you see that nobody else is wearing a buttoned shirt with a collar? Yes. Now have a look and see what's in his hand. That, Your Worship, with respect, even if it was never in picture on a video, that now be taken of that, but it's been placed in the other, which distinguishes this case from explained to me, and this is what was said, the reaction of these sets of questions, all taken together cumulatively, could not possibly have caused a reasonable suspicion or apprehension of bias on my part. For me, with respect, Your Worship, the answer has to be that one must err on the side of caution in this regard and not attempt to wish away the facts or push away the facts with a view to proceeding with a trial that will thereafter, in my respectful view, be tainted and, with respect, bring the administration of justice into disrepute. I have no further address, Your Worship, unless the court wishes to hear any particular thing. Thank you.
Thank you. Advocate Matthews.
Thank you. I'm going to write on the coattails of my learned colleague who has comprehensively placed before the court what is the legal position pertaining to this aspect. We are fortunate that we have a rehearsed judgment by His Lordship Mr. Justice Kuhn in the matter of President Zuma. Now, he has set out in this judgment all factors which are applicable to this court. I want to highlight only one factor, and that is in paragraph 44 of this judgment, where he refers to the decision of State versus David, 1991, Volume 1, South African Criminal Law Report, that's page 375. In fact, an Namibian decision. And he quotes, he says, "It is no answer for the judge to say he is in fact impartial, that he abided by his judicial oath and there was a fair trial. The administration of justice must be preserved from any suspicion that a judge lacks independence or that he is impartial. If there are grounds sufficient to create in the mind of the reasonable man any further part in the case, no further investigation is necessary, and any decision he may have made cannot stand." This brings us to the issue, man, a doubt of that we know that the identification of and the prosecutor, when leading the witness of that, leading the evidence of that witness, quite correctly didn't go to that. If he had, I would have suggested any reason to conclude that this was clarification of the case. And if I may refer also to the second instance, the first two videos, where you address the witness as to the dress of a certain person on the stage who, by all intents and purposes, was the first accused. Stage to the person who was standing on the edge of the stage. Again, insists in the middle of the stage. And that resulted in the fact that you and I is holding something in his hand. What is he holding in his hand? Testified that he'd never seen that video before. In fact, he had just downloaded the video he had, or a video. He had never actually personally seen that video. Your questions to this witness were so leading that the witness himself said, "If you say so." If you say so, that his clothes are that, if you say so. Well, lady, I don't know what the purpose of your questions were, but I have no doubt that that has created a reasonable, that those are sufficient grounds to create in the mind of a reasonable man a doubt about your impartiality in this particular matter. Thank you.
Thank you. Is the state ready to reply or wish to reply, Advocate Caesar?
I'm ready. I'll try to be brave. I'll try to be brief and brave. Allow me to just speak about the personal experience I had when I attended my pupillage. I drafted a very fancy document where we were supposed to go to Stellenbosch to attend our practical training for pupillage. Arriving there, we were put into different groups. I ended up with a Hong Kong group, and this person had to check my fancy document, and he just scratched through it in front of me. I felt like slapping him at the time. But while I was doing it, he was just saying legalese. Why don't you simplify your argument? That's exactly what I'm going to try and do in this particular matter. Yusuf, firstly, I'm opposing the application for yourself to recuse. Of the notice of motion, in terms of Rule 55, it's my submission that it does not comply because I don't even know whether I've got locus standi. The prosecution should have been cited as we have a direct interest in the outcome of this particular matter. If I only was provided with this the application is that you recuse yourself. I'm of the view, and it's the state's submission, that it would not be. I wonder if I can. Aling Yebo, that's the king. It's a Supreme Court of Appeal decision. I also wish to hand in a copy to the court.
Thank you.
I want to cite it. It's State versus Ndalingiyebo. It's a 2016 in brackets 1 SA. They had to also deal with a particular matter where the king, Ndalingiyebo, have requested judgment. It doesn't have a page number. The heading of is the complaint that the trial judge unjustifiably descended into the arena, rendering the trial unfair. If I read from paragraph 25, we now address the appellant's complaint that Elkamar J repeatedly and unjustifiably descended into the arena, thereby rendering the trial unfair. It's referred to in I must get some glasses. 8.1. Is your worship there?
Yes.
Observations according 8 age. According to the well-known dictum, and if I quote, a criminal trial is not a game. And a judge's position is not merely that of an empire. It's one that's not of an empire to see that the rules of the game are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He has not only to direct and control the proceedings according to recognized rules of procedures, but to see. So in other words, what they're saying, Your Worship, is not only as a referee between the parties. You also have to be actively involved, and you ought to need to ask questions if you're not sure. You should not deprive yourself of the advantage of calm and dispassionate observations. The judge is therefore entitled to elucidate the truth more fully in respect of relevant aspects of the case. They refer to Wigmore on evidence, 3rd edition, volume 3. The citation is there. I don't want to go through all of that. Of leading questions, there's no application to the relation between the judge and the witness. But transpired. The learned author differentiate that relation from one between the counsel and that between the witness. He calls that the witness may perhaps think that such questions are an invitation, suggestion, or even an instruction to him to answer them, not unbiasedly or truthfully. What Your Worship did here is nothing untoward. That you are not prevented from doing that. It's not that. Point out that the court is totally entitled to do such. Well, issues briefly. From what has been put by counsel for accused number 1, that's Mr. Malema, that it's not in dispute. If I understand it correctly, I've asked there into the incident. It's further common cause that from what was put to the witness, that shots were, if I understand what was put correctly, I'm standing to be corrected. If that is the case, the only issue that ought to be decided at the end of this trial is whether that indeed was a real firearm. The crux of this case is whether it was a real firearm or whether it was indeed a toy or TV firearm. That's the crux of the case. What Your Worship did and didn't do, it's to me it's very simple. That's all you have to decide in this particular matter. There's no proper ground before you. Your Worship, I want to read through from an article by a particular judge. It's very short. It's a case number SS 40 of 2006 in the matter of Bennett Susan Hillary. It's Susan Hillary Bennett, but it's said the way it's Bennett Susan Hillary. And the second, that was the first applicant referred to in accused now as accused number 2. The second applicant, it's Sporret. He was or she was. Very brief judgment on a recusal application. He said both the Constitutional Court and the Supreme Court of Appeal honed the legal requirements down to include at least a double reasonable test based on a consideration of the correct facts. In other words, if a factual foundation is wanting, then the counsel talking here, which is a distraction, is causing a distraction.
Yes, if I'm correcting or turning on something, it's okay, I mean later. I didn't mean to disturb and I apologize if it disturbed.
Thanks, Ted, for providing. This
Apology accepted, Your Worship.
Thank you.
The judge remarked that there's also in the recusal application, there's responsibilities on legal representatives. We tend to complicate everything as legal representatives. If you go to the public now and go ask them about what they think about lawyers, the answer you would not like, because we complicate everything. There's more and more recusal applications are brought as a tactical device, or simply because the litigant does not like the outcome of an interim order made during the course of the trial. It's our submission, this is exactly what is happening here. An interim order that was made by Your Worship regarding the videos, and they do not like the outcome. The lack of discernment with which recusal applications are being launched or threatened is a cause of concern. It's more and more in these contentious cases. It's time to take a stand. Some standard equipment in a litigant's arsenal, but should be exercised with its true intended objective, which is to secure a fair trial in the interest of justice in order to maintain both the integrity of the courts and the position they ought to hold in the minds of the people who they serve. The risk of recusal applications being used as a strategic tool is that far from securing the integrity of the court. Continually unfounded aspiration on judges may bring about a loss of faith in the judiciary as a whole and bring it into disrepute. In this regard, there is an onus on this we are now into motion applications now. We're no longer dealing with a criminal trial. Rule 55 in the Magistrates Court rules is applicable here. We're dealing with applications. He who alleges must prove. Bishop, there's no proper grounds for this particular application before yourself. I'm not going into all the legalese, and so it's already been done by counsel for accused number 1. Bishop, accused number 2. On Monday when I entered here, he approached me, and I didn't want to go, and he said, I want to see you in front of this legal representative. He said, I want this trial to be finalized. And I said to him, I'll try my best. My submission is that you being recused from this particular matter is not in the interest of justice. It's going to prejudice not only the accused but also the state. There's no sign of bias here. Even if there was, there's sufficient safeguards in the Criminal Procedure Act. If I refer to, there was alluded to by accused number 1, what I would suggest, Your Worship, or what my submission is that counsel ought to have brought an application to make a special entry with regard to this issue, or they've got review or appeal as remedies. It was my submission that you should dismiss this application. Anxiety on the part of the accused is not sufficient grounds. That is my submission. Akan naman.
Thank you.
I don't need to be disturbed the prosecutor, but Your Worship, this response to Farmer's logic, I'm afraid to say. Let's start off with the tail end, if I may, Your Worship, because those are the clearest examples. For an advocate, former magistrate, and I don't mean to become personal, Your Worship, to tell this court that the correct procedure, when you feel prejudice, because there are sufficient safeguards in the Criminal Procedure Act, is to apply for a special entry. I challenge him, Your Worship, to show me where in the Criminal Procedure Act one can apply for a special entry in the Magistrates Court. It doesn't exist. Special entry, if my memory serves me correctly, Your Worship, is in the sense of 316 to 318 of the Criminal Procedure Act and only applies in the High Court. There's no such thing in a Magistrates Court, and I personally challenge him in that report. To my mind, Worship, I've been practicing a few years and I've never ever heard of it. So I don't know why, when you feel prejudiced or biased, there's sufficient safeguards in the Criminal Procedure Act that you can apply for a special entry is nonsensical, and I don't mean to be personal. To further say that you can go and review or appeal is equally contestable, Your Worship, in that one cannot go and review until one has a decision from this court. Even then, there are lots of authority that say, Your Worship, that one must wait until the proceedings have been completed. And there's a tendency against going on review in part-2 litigation. There are instances where it has been allowed. Authorities, Your Worship, or WALHAU, spelled W-A-H-L-H-A-U-S, says you shouldn't delay proceedings by going on a review part heard. There was an exception to that in the Berman versus Additional Magistrate decision. It was allowed, but one has to make out a basis for doing so in part heard proceedings. And when it comes to an appeal, Your Worship, one needs leave to appeal first from Your Worship on every aspect of the law. So I don't want to sound disrespectful, Your Worship, but I am, to say the least, astounded by his response in that regard. Your Worship, the test remains sacrosanct in our law. It has been established. It's straight. It's trite. It's there. There must be bias or reasonable apprehension of bias. The interest of justice is not a test to be applied. It's one of the factors that can be taken into account in applying the test. Additionally, Your Worship, I understood, and I still find it hard to actually believe, that he said that litigants shouldn't use leading questions. It's not advisable to them, but presiding officers may. Assume I've heard him correctly, otherwise he'll correct me. And I've never heard of anything more ludicrous, especially to somebody who refers to his personal experience in pupillage, because the art of cross-examination is the utilization of leading questions. The skill of examination in chief is that you're not allowed to use leading questions. We as defense counsel are obliged, and it would be funny in our duties if we didn't ask leading questions, so I don't understand what he's trying to say. Worship, if one has regard to the spoiled decision in Bennett and Porritt, it was very similar to that of Stretch there. It was litigants involved litigants that were, so to speak, employing a Stalin grade defense that were in circumstances where the trial only began 15 years after the fact. They avoided court, they took chances getting sick. It's a matter of record. It doesn't have any application to your respect, Your Worship. And as a last-ditch attempt, they applied for Mr. Justice Spill to recuse himself without setting out a proper basis for him to do so. If one also has regard, Your Worship, to the other decision that you quoted, the decision of State versus Danindjebo, involving the chief, not the king, Your Worship. In that instance, Your Worship, at the paragraph referred to by my learned friend, the appeal court dealt with the questions that were asked by the judge in the instances and found that they weren't of an interfering nature. There were simple questions. In fact, in most of the instances cited there, they protected the witness from exuberant or unnecessary cross-examination on questions that were illogical or couldn't be answered and would be regarded as being unfair. So the interventions referred to there, in most instances, Your Worship, were to protect the witnesses. That, with respect, cannot be said to be the case here. In every instance, Your Worship, the questioning by Your Worship took place after they have a form of examination. It was post the testimony when the court was seeking clarity and asked questions, and it was in that context that they arose, so they do not, with respect, apply here. Your Worship, my learned friend has made it clear that he is aware that the videos were in dispute. Your Worship made a ruling, we abide by it. We've never taken issue with it, Your Worship. We never took you on review. We conceded, Your Worship, that there were two different approaches. They're from the same year, from the same division, and there was the possibility of regarding it as real evidence as opposed to regarding it as documentary evidence. We alluded to that conflict in the law and those conflicting decisions. We argued in favor of the one, not the other. Your Worship has a discretion, but to say that this is premised on that, Your Worship, is totally out of bounds. It's not the case with respect. Whether we like your decision or not isn't the fact here, Your Worship. This is premised on a very strict factual basis, Your Worship. I also don't know how my little friend received papers at 2:10 this morning. I can tell you, Your Worship, they weren't ready at 2:10 this morning. They were still being printed and hadn't been signed. So at that time, as a courtesy to this honourable court, my little friend is not a cited party. He's an interested party who was provided with a copy of the papers. We could very well, Your Worship, have launched an application with no papers. It was purely to detail and to provide an opportunity and in fact to show respect to the court to do so. It's not a motion proceeding, it arose in the nature of criminal proceedings. This is a criminal trial. Your Worship doesn't go change your gown and put on a civil gown to now start a motion court. This is a criminal matter. It's an application for recusal in a criminal matter and does not have anything with respect to do with sitting as a motion court and attracting a different onus. We have a test, a legal test that applies, that is evident from all of the authorities, from the Constitutional Court downwards, including the Supreme Court of Appeal, to show that there was bias or a reasonable apprehension of bias. He has not, with respect, even attempted to deal with it. I haven't heard him mention it even. He may refer to it in his all-encompassing reference to legalese. It's the test. I can't change it, Your Worship. That's the legal test. I don't hide behind legalese or legal terminology. That, with respect, is the test as established by our courts, all the way up to the Constitutional Court, and I don't believe my own friend would tell him this is legalese and that it can get crossed out by his person marking his examination. Your Worship, I do not believe that there has been proper opposition to this application by the state. We stand by our apprehension of bias on the part of the accused that was borne out with respect Worship, with the factual examples given in the papers. No further addressing this, Your Worship, wishes to turn of any particulars.
Thank you.
Your Worship, this morning I approached my learned friend now that he wants to get personal. And I told him,
I didn't hear your first part this morning.
now that he wants to get personal, I told him that because of various factors, including, I almost want to say this useless ESCOM, but I should. We sat in the dark for most of the night. We have, under severe circumstances, drafted this application. I told him this morning, I'm sorry, we're going to only give it to you now. Please indicate to us if you want more time to consider it. We will gladly concede to it. Why he now mentions that he only received it at 10 o'clock is puzzling to me, because he should tell us now if he needs more time, we should stand down and he can go off and do what he wants to do. His remark that there's a duty on counsel, a responsibility on counsel in a matter such as this, is the very thing that I addressed you on. To say to you that we have seriously considered this, we have listened over and over to what happened, taking the advice of our clients. This application was not brought because of any anxiety on our part, because we don't like the ruling as regards the admission of the video. We didn't tell you to recall the witness. We didn't tell you to tell the witness to look at clip number 3. We didn't ask you to ask any of the witnesses to do what our conduct, that conduct which we complain about. Already, the interest of justice is not the test. The test is set out very clearly as to what a recusal application is or isn't. Thank you.
Thank you. Everyone done. What we should decide on is the time for resumption for judgment or ruling by court. If it is
Your Worship says, not situation.
Since I'm aiming at responding to the grounds and dealing with the law, I don't anticipate that I will need more than approximately 15 minutes for time, or I need preparation time. So, quarter to 3, then we can deal with it today.
As Worship is entirely.
Is it suitable, the time suitable to all parties?
It will be.
Yes, yes.
If anything goes wrong, or if we shed into darkness and I cannot access my laptop, well, then the picture will change, as it did on Tuesday. So, okay. Then we'll resume at quarter to 3. If there's anything that changes, I will inform either warrant officers Forster or Kinard to inform you. We'll hope for the best. Thank you. Go to the chair. doing. Further, asking the witness, and that would still mean Mr. Singh, what his job, or Mr. Singh, the last witness, Mr. Mkwacha. Assist me, please.
It's Quata.
Quata, thank you. What his job description entails at Gear House, and whether he had checked the equipment on the said day, and whether any problems were reported in court as the senior AV technician. To even allege that this evidence favors the state baffles the mind. With regards to the second applicant, again referring to paragraph 6, and based on the argument by Advocate Matthews that the respondent was using this witness to attempt to identify applicant number 2 as being the person and one on the video, the only reply to this would be, it also baffles the mind, as the video does not show faces and merely a glimpse of the back of a male person. Once again, such evidence does not favor the state in any manner, neither does it bolster the state's case. I would say the opposite may be a more accurate assessment. The court now refers to the matter of Pumlani Mkolo and the state, delivered on 28 April 2022 by the Honorable Judge Stretch, sitting in Bishu, case number CC 40 of 21 Eastern Cape Division, Makanda. It's described that the doctrine of recusal has its origin in the rules of natural justice, which requires that a person or an accused should have a fair trial. This common law position has since been entrenched in the Constitution of the Republic of South Africa. Especially I refer to section 34 of the Constitution, which affords everyone in this country the right to have any dispute that can be resolved by the application of law to be decided in a fair public hearing before a court. Section 35 is similar in that it guarantees a fair trial for persons or accused of criminal conduct. Section 165, subsection 2 of the Constitution requires courts to apply the law. 2 of the Constitution requires a presiding officer to swear that he or she will uphold and protect the Constitution and will administer justice to all persons alike without fear, favor, or prejudice. Further, Article 13 of the Code of Judicial Conduct states that a presiding officer must recuse him or herself if there is a real or reasonably perceived conflict of interest, or if there is a reasonable suspicion of bias, if it is based on objective facts. The Constitutional Court has summarized guidelines for the recusal of judicial officers. To mention but one is it must be positions. They should further keep in mind that they have a duty to sit in any case in which they are not obliged to recuse themselves. It must be considered that an impartial presiding officer is a prerequisite for a fair trial, and a judicial officer should not hesitate to recuse herself or himself if there are reasonable grounds on the part of the litigant that the judicial officer, for whatever reason, was not or will not be impartial. Further, in State v. Legransi and others, 2009, 1 SACR 125, Supreme Court of Appeal decision by Colopin J, identified 3 core principles. They also refer to State v. Duma and others. It is an unreported matter, GP, case number A 423/2015, delivered 12 April 2017 at paragraph 15. When addressing the issue of the impartiality of judicial officers, there is a presumption in our law against partiality of a judicial officer. This is largely based on the recognition that legal training and experience prepares the judicial officer to determine whether the truth may lie in the face of contradictory evidence, that the presumption of impartiality is not easily dislodged, cogent, and convincing evidence is necessary in order to do so, that fairness requires the judicial officer to be actively involved in the management of the trial, to control proceedings and to ensure the proper utilization of resources. It goes without saying that this sometimes involves assertiveness and the adopting of robust stances. At the end of the day, the vital ingredient of a fair trial is that justice must be done and be seen to be done. It should further be noted that applications of this nature involves a value judgment of the court applying prevailing morality and common sense. In I refer to Take and Save Trading CC and others versus Standard Bank of South Africa Limited, 2004, 4SA1, Supreme Court of Appeal, where Harmse J.A. stated that a judicial officer is not simply a silent umpire. Fairness of court proceedings requires of the trier to be actively involved in the management of the trial, to control the proceedings, and to ensure that public and private resources are not wasted. Remarkably, in the course of dismissing a recusal application in Bennett and another versus the State, 2021, 2 SA 439, G to J, Spills J remarked that more and more of these applications were being brought, be it as strategic or tactical tools, the recusal of a presiding officer should not become standard equipment in a litigant's arsenal, but should be exercised for its true intended objective, namely, to secure a fair trial in the interest of justice, in order to maintain both the integrity of courts and the position they ought to hold in their minds of the people whom they serve. Ongoing, unfounded aspirations cast on judicial officers could bring about a loss of faith in the judiciary and bring it into disrepute. Judicial officers must apply an objective standard and measure the facts against that standard. In Shackle, 2001, 2 SACR 185 SCA decision at 19 to 25, the Supreme Court of Appeal articulated the test for reasonable apprehension of bias as follows. The apprehension of bias must be reasonable, held by reasonable and right-minded persons, applying themselves to the question and obtaining thereon the required information. The test that would an informed person viewing the matter realistically and practically and having thought the matter through conclude. I now turn, no. Therefore, it can safely be accepted that this court knows that an accused person is innocent until proven guilty, no matter what the charge sheet may allege, and no matter what witnesses have said or are about to say. This court is alive to the process that is to be followed, and that the prosecution carries an onus to prove the guilt of persons it accuses beyond a reasonable doubt. Whatever the position may be, it can never reasonably be suggested that because this court utilized its right to ask questions from witnesses with the objective facts in mind, that it has trampled on the presumption of innocence. It can also hardly be suggested that a reasonable, objective, informed person in the position of the applicants would reasonably perceive bias upon hearing questions by court conducted in accordance with procedure, which questions is not limited to evidence in chief or limited to what is emanating from cross-examination, but which aim is to obtain information and objective facts. Nothing more and nothing less. This court is alive to the process that the prosecution carries this onus to prove the guilt. Having applied my mind to the applicant's request for my recusal and that proceedings should start de novo before another magistrate and or alternative relief, I wish to thank the applicants, that is Advocate Odes, Advocate Matthews, for well-drafted applications, for providing the court with extremely relevant case law. It is much appreciated. I have also considered the argument by Advocate Caesar and the state's stance of opposing the said application. I can assure you that my finding today is void of any emotional sentiments as far as it pertains to the application, and it is not seen as a personal attack on this court in any manner. The court has indeed applied its mind and excluded any or all subjective interpretation in the law of judicial recusal. Therefore, in my view, all that was established by this court during questions by court is indeed, just a minute, my eyes here is not working. I'll start again, my eyesight is not that good. Therefore, in my view, all that was established by this court during the questioning by court was indeed a process in which the court may clarify issues and obtain objective facts. That is what this court established. Applicant 1 and 2, you may stand up, please. For the reasons I have mentioned, and I have answered all your concerns in all the paragraphs cited on the application, I've given reasons for it, and therefore I find that the presumed bias you may feel is unfounded, and the application for the recusal of myself in this matter is refused.
Is the court please?
Thank you. You may be seated, thank you. Advocate Otis, may I inquire at this stage if you want to take instructions as to special review?
No, we're ready to proceed, Your Worship.
No, remember there is still...
Yes, Your Worship, I have instructions in anticipation. I can make it known without anything. I was instructed if the application is refused to proceed to trial.
But I wanted to indicate clearly that should you wish to take it on review for the High Court to decide, I am willing to follow that process and to accommodate.
My instructions are to the contrary. I have no doubt about that. The accused will confirm it. Yes. No, I was advised in advance, Your Worship. Thank you.
Okay. Definitely not going to proceed today. Are we continuing tomorrow? I don't know what the load shedding schedule is like.
Bishop will be having electricity from 9 to
Why are you
12.
echoing? What's going on? Why do you have
It's a
echo?
microphone, yes.
Oh,
From 9 to 12, there will be electricity. After that, there will be load shedding, Your Worship.
so it means?
Echo.
It means then we have 9 to 11:30.
Yeah.
Because we have to switch off 30 minutes before. So, is it worth your while?
I'm in my learner friend's hands.
As I've stated, I don't know who's coming, who is still to come, how long they will be. I can't say. I'm available, but if there's time to finish one, you will know better than I do.
Your Worship, what I intend to do is just to call two short witnesses. I don't think the evidence will be really challenged as it will only be...
Oh, I'm taking nothing for granted. Evidence will never be
No,
challenged.
I've observed the trend, Your Worship, relating to the evidence.
Let us not follow the road.
There wouldn't be much to ask them, other than the change. Because
Assume nothing, Advocate Caesar. Assume nothing and just answer. One witness, two witnesses, will we have time?
for one, Your Worship.
Are you happy with that?
Yes, Your Worship, thank you.
No wish to fly home today.
No, Your Worship.
Yeah, I so wish to fly home today.
Your Worship.
Advocate Matthews, you wish to fly home today?
Not really.
Oh,
I quite enjoy London.
it's
I've been to some
entertaining.
nice restaurants to eat.
It's entertaining, isn't it?
Yeah.
Hmm. So
No,
there's no one who
my lady,
supports any of my decisions and requests.
We have flight arrangements for tomorrow afternoon. We don't want, it will not be possible to change them.
All right, let's utilize the time that we have from 9 till 11:30 so that no time goes wasted. I know in the beginning of the week, Advocate Otis, you indicated we should have a discussion regarding the further dates, which may, so if we could possibly do that before 9 o'clock so that we don't waste time
Thank you, Your Worship.
during the court. So you and the state, whoever may, feel free to come to chambers at any stage to sort out that
Thank you,
issue.
Your Worship. Thank you.
All right then, accused 1 and 2, you may stand up please. Any requests to fly home today?
Please take.
The matter is postponed until tomorrow, the 3rd of February. Both of you warned, I would say, Regional Court 1, 30 for continuation of trial. Thank you, you are excused.
Your Worship, that's our roll in for today. Can we postpone it? Can we adjourn?
Thank you. I just want to endorse. You may be seated, you may even stand down. There's just a bit of admin I agree with. No, it's fine. You're off record. It's fine. Go ahead. Thank you. Court is adjourned.